Welcome to In Solidum Lawyers. Today we delve into the world of conflict mediation. Are you ready to clear your doubts? Greetings to everyone joining us today. I'm Jose Ramirez, manager from In Solidum Lawyers. In today's reality, conflicts, be they personal, business, or work related, are inevitable. However, how we choose to address and resolve these disagreements truly makes all the difference. You might have come across the term mediation before, or it might ring a bell if you've been involved in a legal dispute. Mediation is more than just a term, it's a path to resolution, an alternative to often lengthy and tedious judicial processes. But what does it precisely entail? And even more importantly, how can mediation serve as a beneficial tool in the Ecuadorian legal framework? Today, our aim is to provide you with a clear insight into this alternative dispute resolution method, shedding light on its significance, its workings, and the advantages it offers, especially in a context as diverse and dynamic as Ecuador's. We're here to answer your questions and give you a comprehensive view of mediation. So without further ado, let's dive into the topic. At its core, conflict mediation represents a shift in how we approach disagreements and disputes. It's a process that, rather than pitting parties against each other in a prolonged and often draining legal battle, centers on understanding, dialogue, and finding common ground. Now, let's delve a bit deeper. Picture two individuals with opposing views on a specific issue. Instead of heading to court, where a third party decides for them, they choose to sit in a neutral setting with a mediator's guidance. This mediator isn't there to make decisions for the parties, but to aid them in communicating, understanding one another, and ultimately arriving at a solution both can be content with. The key word here is collaboration. Within the Ecuadorian context, mediation has proven to be an invaluable tool, not just for its efficiency in terms of time and resources, but also because it promotes a culture of peaceful and constructive dispute resolution. Moreover, in a legal environment where litigation can be protracted and expensive, mediation emerges as an alternative that respects parties' autonomy and encourages creative solutions that a traditional judicial process might overlook. For many, the idea of finding joint solutions and avoiding a direct courtroom confrontation is a much more appealing and effective approach. And in Ecuador, with our rich tradition of dialogue and understanding, it's no surprise that mediation is the go-to choice for many. Mediation is a versatile tool that adapts to a wide range of situations. Nevertheless, there are certain contexts where it truly shines and demonstrates its utmost potential. Consider, for example, two business partners facing differences in how to run their business. They have years of collaboration and even thought there are differences now. They wish to continue working together in the future. In a case like this, dragging the conflict to court might irreparably harm the relationship, leading to the dissolution of the company. Mediation, by promoting dialogue and mutual understanding, can assist in finding solutions that both parties deem fair, allowing the business relationship to persist. Similarly, family conflicts such as inheritance, disputes, or disagreements between parents and children can benefit from mediation. In these situations, mediation can be a way to solve problems without deepening emotional wounds or causing lasting divisions. In the labor arena, where employees and employers seek to maintain a constructive working relationship despite disagreements. Mediation might be the key to resolving conflicts without resorting to dismissals or resignations. What makes mediation especially appealing in these scenarios is its ability to provide tailored solutions that fit the needs and circumstances of the involved parties. Unlike a judicial verdict, which can be seen as imposed, mediation is based on consensus and mutual understanding. Of course, not all situations are suited for mediation, but when the goal is to maintain long-term relationships, find creative solutions, and avoid the strains of a judicial process, mediation emerges as an excellent option within the Ecuadorian legal landscape. The mediation process in Ecuador is designed to be fair, confidential, and above all, solution-oriented. While it may seem straightforward, it results from a structured and methodological approach. Firstly, it's crucial that both parties involved in the conflict are willing to mediate. This means they must voluntarily agree to undergo the mediation process, understanding it as an alternative to litigation. Next, a mediator is chosen. It's essential to note that this isn't just any individual, but someone specifically certified and trained to perform this role in Ecuador. The mediator has no personal stake in the conflict, ensuring a neutral and objective stance. Once the framework is set, the mediation session occurs. Here, parties have the opportunity to express their viewpoints, concerns, and expectations. The mediator serves as a dialogue facilitator, ensuring each side is heard and the conversation remains respectful and constructive. Unlike a judge or arbitrator, the mediator doesn't make decisions or impose solutions. Their role is to help the parties find common ground and come to an agreement on their own. If an agreement is reached, a document detailing the agreed terms is drafted. In Ecuador, this document has legal value and is binding, meaning parties are legally obligated to adhere to what they've upon settled. What's beautiful about this process is that, unlike traditional litigation where there's typically a winner and a loser, mediation allows both parties to feel content with the outcome. As they've been actively involved in crafting the solution, it's a more human and collaborative way to address conflicts in the legal world. Mediation as a conflict resolution method presents several advantages that distinguish it favorably from other alternatives, especially the traditional judicial process. First, efficiency in time and resources. One of the most immediate benefits of mediation is its speed. Instead of spending months or even years in court, mediation can resolve a conflict in just a few sessions. This swiftness is not only convenient, but also reduces the cost associated with a prolonged legal process. Second, control over the process and outcome. In a trial, a judge or jury makes a decision that may or may not favor one of the parties. In mediation, the parties themselves, guided by the mediator, seek and agree on a solution. This gives the parties a greater sense of justice and satisfaction as they play an active role in the outcome. Third, confidentiality. While judicial proceedings are mostly public and the case details can become public knowledge, mediation takes place privately. This protects the reputation of the parties and ensures that sensitive matters are handled discreetly. Fourth, preservation of relationships. The collaborative nature of mediation often allows parties to maintain or even improve their relationships. This is particularly valuable in disputes where the parties have an ongoing relationship, like family or work conflicts. Fifth, flexibility. Unlike the rigid procedural framework of courts, mediation allows the parties and the mediator to adapt the process to the specific needs of the conflict, leading to more creative and suitable solutions. In summary, mediation is not only an appealing alternative because it's faster and more economical, but it's collaborative and confidential. Approach makes this a powerful tool for resolving conflicts fairly and efficiently in the Ecuadorian context. The mediator's role in the mediation process is essential and multifaceted. Here I explain their function in more detail. First, impartial facilitator. Above all, the mediator acts as a neutral facilitator. It is not their role to take sides or impose solutions. Instead, their primary task is to ensure that all parties have an opportunity to express their viewpoints and concerns. 2. Promoter of constructive dialogue. One of the main challenges in any conflict is ensuring a constructive dialogue. The mediator employs specific techniques to prevent the escalation of tensions and ensure the parties listen to each other, fostering respectful and productive exchanges. Third, clarifier of issues. In many cases, conflict may arise from a misunderstanding or erroneous perceptions. The mediator assists parties in identifying and articulating their true concerns, ensuring all issues are understood clearly. Fourth, guiding seeking solutions. While the final decisions lie with the parties, the mediator can introduce options and alternatives that the parties might not have considered and assist them in exploring possible solutions that meet everyone's needs. Fifth, guarantor of confidentiality. The mediator ensures discussions during mediation remain private, facilitating open sharing of information and expression of concerns by the parties. Sixth, drafting the agreement. Once an agreement is reached, the mediator aids in drafting a document that faithfully respects the agreed upon terms, ensuring it's clear and understandable. In essence, the mediator is a pivotal piece in the mediation process. They act as the bridge, facilitating communication between conflicting parties, ensuring the process unfolds in an atmosphere of respect, empathy, and cooperation, ultimately aiming to reach an agreement beneficial to all involved parties. We live in times where conflicts, whether personal, commercial, or label related, are inevitable. However, the way we choose to confront and resolve these conflicts can make a significant difference in outcomes and our future relationships. Mediation emerges as a modern, humanistic, and highly effective response to this reality. It's a process that not only seeks to resolve the conflict itself, but also values the relationship between the parties and aims to preserve it. The key to success in mediation lies in mutual understanding, respect, and above all, both parties' willingness to come to an agreement. Instead of an adversarial approach, as might be the case in a trial, mediation fosters a collaborative environment where solutions are built together. At In Solidum Lawyers, we understand the relevance and value of this process. We are committed to promoting alternative conflict resolution methods that are fair, efficient, and beneficial to all involved parties. If you find yourself facing a situation requiring mediation or simply wish to learn more about how this process can assist you, we invite you to approach us. Our team of experts is here to guide and support you every step of the way. This has been a deep yet essential journey into conflict mediation, an area we deem vital in today's legal world. We appreciate your time and interest in learning and educating yourself alongside us. If you value this kind of content, we invite you to press the subscribe button so you won't miss any of our future releases. Moreover, if you believe this information could be valuable to someone else, please don't hesitate to share this video. We hope to see you soon in more of our educational content. And remember, for any inquiries or legal assistance, at In Solidum Lawyers, we are always ready to offer you top-notch service because your safety and legal well-being are and will always be our utmost priority. See you next time.